Are traumatic brain injury cases involving children handled differently? Attorney Stuart Casper says, yes, to some extent. The biggest concern with a pediatric brain injury client is that the pediatric brain is constantly evolving and developing. So when we secure an assessment of a youngster with a traumatic brain injury, we do so keeping in mind that the brain is developing, and it's more difficult to predict what the future will hold in store with the developing brain. Interestingly, the pediatric brain both develops new cells and sheds some cells that are unnecessary. It's incredibly unfortunate that in Connecticut, the statute of limitations is 2 years, regardless of whether the injury occurs to a 25-year-old or a 5-year-old. In almost every other state in the nation, there is a tolling provision for minors that either delays the statute of limitations until the child reaches majority or some period of time after majority, or at least adds a number of years to the statute of limitations. Such flexibility for a minor reflects an understanding that by forcing a minor into court prematurely because of a short statute of limitations, the ability to adequately protect the injured minor can be seriously compromised. Because Connecticut has a short statute of limitations, the approach taken at Casper and Toledo when a child is involved is to wait until almost the expiration of the statute of limitations to get at least that 2 full years before we file the lawsuit. And then we try to delay the progression of the case for as long as we can. The ability to do that will vary from judicial district to judicial district. We take this approach because it's unfair to the child to force the case on the same sort of accelerated schedule that every other case is on, because healthcare providers and the attorneys won't be able to fully assess the damages that way.
For a free phone consultation, contact Attorney Stuart Casper in Stamford, Connecticut at 203-325-8600 or visit his website at www.casperdeToledo.com.